This presentation is on Islamic law. Now, I would say that of all the topics we're going to be covering, there's probably the most disinformation, that is, wrong information about on Islamic law on this topic than any of the others we've discussed so far. Um, there's also probably, I think, the greatest gulf between the classical Islamic traditional view of Islamic law and the modern view in some regions of the Muslim world. So I'll be discussing this in this. I'll be discussing the classical view in this talk, and we're going to turn to the modern view at the very end in a little bit for the next discussion. I'd like to fix a couple of terms associated with Islamic law for you. The first is the one I suspect you've heard, Sharia. And the second, I suspect you have not heard yet, fiqh. Of these two, for our purposes, fiqh is the one we're going to use most often for reasons I'll explain now. Sharia is really a concept rather than a field. And Sharia is, the concept is this, that God has set out a path of right actions. And that path, in other words, what God wants us to do, what he wants us to practice, how he wants us to pray, all of these things are known as Sharia. That is, this is the law with the capital L, as God wants us to carry it out. Fiqh is the field through which one can come to know, as best as humanly possible, the Sharia. So in other words, fiqh is applying one's intellect to the unimpeachable sources of the Quran and Sunnah to determine what the Sharia is. And this is taken as a human intellectual endeavor. So the goal is getting to the Sharia, but there's an appreciation of the jurists that there's a range of certainty on these issues. So in some ways, it's quite similar, I think, to constitutional U.S. law in that with the Constitution being in the place of the Quran and Sunnah. In other words, there's a consensus that we're going to, the courts work on the basis of the fact that the Constitution is what we're following, but they disagree on interpreting it. And so too, Sharia is the agreement that this is what we're striving for. We want to carry out its dictates, and fiqh, which literally means understanding, is how we get there. So really, this presentation is on fiqh. So a couple of other concepts just to be clear. Ultimately, the source of this legislation, as God set it out, is God who set it out. So God is ultimately the legislator, and I hasten to add, not the prophet. The prophet is guided by God, and as a guided messenger, his model is one that we follow. But it's divinity, it's God who's setting out the law, and the law is extremely important in Islam, and thus it's been described as an orthopractic tradition. In other words, one in which practice rather than belief is central. And as I've said to a couple of you in the discussion sections, one can overstate this. I mean, belief is also important, but it is true that law covers a great many more categories in Islam, as in all religious traditions, than you think of law. So it's not just prohibitions; it's also prescriptions. How many times one prays? What does it mean to wash correctly? What are the rituals? And also there are things which are advisory, that gives you merit, such as how to greet someone, for example. So pretty much anything you can think of in some ways is covered in the law. And the ultimate goal of the law, unlike in our society, which we may say, well, the goal of the law is to be able to live in a society or something like that. The goal here is personal. It involves your capacity for salvation. In other words, in getting into heaven. So this is quite clear. So ultimately, it is God who carries out the law, not the government. Not the government. The government is charged with enacting, with providing a society in which it's possible to have an Islamically good life and thus get to heaven. So there's certain specific laws which the government is enjoined to carry out in this world, but ultimately, the law is something between you and God, and with God being the both the legislator and the judge after you die. So whereas in our laws there are things that you are not allowed to do, prohibitions like going through a red light or murdering someone, and things that you're obligated to do like pay taxes or pay child support if you're divorced, for example. In Islam, there are more categories. There are these five things that are obligatory, recommended, permissible, reprehensible, and forbidden. So all acts are that are covered in Islamic law, which is most everything, are given one of these five categories. So to give you an example of a recommended in which there's merit but no punishment would be, for example, attending to the sick. Somebody is ill in your family or a friend or just someone on the street, helping them out. This is something that's recommended. It will give you merit, but not to do it does not give you any punishment. Something that's obligatory is, for example, prayer, Jummah prayer on congregational prayer, or fasting during Ramadan, etc. Permissible is basically things that are indifferent to the law. So, for example, taking a walk in the fresh air, as opposed to, or let's just say, taking a walk when it's sunny out, sunny being a bad thing because it's very hot. The law's not going to reward you for this. It's just permissible, but not recommended. Reprehensible would be something like divorce. Something there's no punishment, but it's a demerit for the afterlife. It's not good. And forbidden something like eating pork, usury, that is taking, getting profit from lending money, drinking wine, any number of things. So the important point here is that it's not only about being something just being forbidden or prescribed. There's all these different categories, and again, I hope this helps you see that ultimately what's important is your status for the next life. That's the by far the strong emphasis for the jurists who take this life is much less important than the next life. That's a principle which guides their thinking. The next life being, in other words, your afterlife in heaven or hell being eternal, and this life being transitory. I want to give you just a definition of fiqh, and this is a juristic definition. In other words, the one that the jurists give. And I'm really channeling here one particular jurist who's a famous 12th century Sunni jurist. Al-Amadi is his name. But you don't need to know that, but I just thought I'd let you know. I mean, there's one has to sort of pick a point, and this is the mature classical Sunni juristic tradition. And Amadi, following a long line of predecessors, defines fiqh as discovering the intentions of the lawgiver. Discovering the intentions of the lawgiver. That is, what is God's intentions in His commands and prohibitions as we can see them in the unimpeachable primary sources. So it's quite, if you might gather from this, the jurists are a fairly confident, bold group. I mean, it's quite something to say you can not only understand what God wants, but you can understand what He intended when He gave this or that command, and that's what they assert. Just to give you a few categories, sort of broad categories that often occur in legal manuals, ritual purity law covers a whole lot of, and this tends to be quite a long, extensive section, as does family law, which covers also laws of inheritance, marriage and divorce, dietary laws, obviously, I think fairly clear. Torts are when there's a case Muslim against Muslim. Contracts, in other words, a tort would be, if you hurt yourself at somebody's doorstep, who's, what's the what does the other person have to pay. Contracts, contract law, criminal law, and law pertaining to governance. All these are just kind of just to give you some idea of the topics one finds in a legal manual. I like this. This is from Marshall Hodgson, giving you the derivation of a legal decision. That is, how does fiqh work? It's starting from, in other words, from how does it get from God to an actual decision? And this helps. Let's just look at the terminology here. So this kind of puts it all out there on one page, what I'm going to be talking about this lecture. You have God as the ultimate source, as reflected in the Quran on the one hand, and the Sunnah, that is the practice of Muhammad, on the other. The Sunnah is reflected, one finds the Sunnah, the practice of Muhammad, in hadith reports on the one hand, or by consensus of the community on the other. And you can see the hadith are verified by the isnads. If we go down a bit, ijtihad, this is the inquiry, the reflection by someone who's qualified to do so. So ijtihad, which you see has the same root as the word you probably know, jihad, which is usually in classical times means just war. In this case, the same root with the JHD, but with different letters around it. It means striving as an inquiry. In other words, intellectual striving by someone who's qualified to do so. That is mujtahid. And when one does that, it's fiqh. And by the fiqh, one determines the sharia, the law, the way of the faithful. And a jurist who's done that, who's qualified to give an answer to a question, gives that answer to the question is called a fatwa. And if it has a bearing in by the government, you get a qadi, a court judge who issues a qada, a court judgment. And then he gives this nice example. For instance, someone wants to know, is it proper to use a toothpick after meals? And so he asks maybe his local imam, and the imam looks into this and he says, look, Muhammad did use a toothpick after meals. That is the sunnah. And there's a hadith that's been verified through isnads. A mujtahid looks into this and decides this is something that is for everyone. And that derivation is really the fiqh. And it is therefore included in the sharia, that it is what God enjoined. However, so the mufti who's asked the question says, yes, you should do it. It's recommended. And so the qadi, there's no place of the courts in this. The qadi has no bearing on this case. It's purely a personal matter which might affect the believer's afterlife. So this is actually a useful slide to go through for all the terminology all in one place. The one thing I didn't talk about that's important is qiyas. You see under Quran, and qiyas you can see means analogy, and so basically it's taking something that's known in the Quran and applying it to a new case, and I'll be talking about that below because that's really the heart of what we're talking about here. Another significant category that we need to that I need to introduce you to is this one, al-hudud, which is actually the plural form, but let's leave it as in the plural. These are laws in which the prohibitions and punishments are mentioned in the Quran. God specifically said, do not drink alcohol, do not steal, do not commit highway robbery, do not commit adultery, do not falsely accuse someone else of adultery. And for each of these, he gave the specific punishment of what one does with someone who commits highway robbery or adultery. And because of this, according to the jurists, if one commits one of these, it's not just an infraction against a fellow Muslim, it's an infraction against God directly, because God was quite clear in his prohibition and quite clear in the punishment. And because it's an infraction against God directly, it's up to the caliph, that is the leader, to enact it. Well, to execute the punishment if someone is found guilty of committing one of these acts. So it has a special category in Islamic law. And what's been controversial in the modern period, or the post-classical period, I should say, is whether one carries out the hudud if there is no caliph present who's accepted. So, for example, as we don't have a caliph who's accepted today, um, um, and there's no Islamic empire that the caliph rules, do the hudud go in abeyance? That is, do we not carry? There's no government to carry them out, and Saudi Arabia sort of famously takes on the role, takes this on, as does Pakistan, of carrying out the hudud penalties, whereas most governments do not. They don't. They say that there's no caliph. We are not really a caliph, our modern government, so we don't carry them out. I want to turn to the history of Islamic law and its development, and this is going to have some bearing on the text I'm having you look at, which will be important for your exam. So do listen to this bit, even though it doesn't sound very important. And it's this, that in the early period, there were these regional schools of Islamic law. And so you had the Hijaz. The Hijaz is that small strip of the Arabian Peninsula that includes Mecca and Medina. You had the Hijaz and the Iraqis, who are also known as the Kufans, and just as the Hijazis are also known as the Medinans for Medina. So in the very early period, you had sort of this kind of language. The jurists of Hijaz hold thus versus the jurists of Iraq or the Kufans hold so on a particular issue. In other words, there are disagreements by region based on the different practices of these different regions, which establish their own kind of custom. The reason this isn't just an act, sort of a not terribly important trivia, is that being a traditional idiom, Islamic jurists tend to continue to use this regional language in later periods. And so when they talked about the Medinans, they're actually talking about, or the Hijazis, they're actually talking about a law school that would become the Maliki law school, which I'll introduce you to in the next slide. And when they use the language of the Iraqis or Kufans, what they're really talking about is the Hanafi law school, because its founder, Abu Hanifa, was from Iraq. So in other words, again, a palimpsest religion, traditional society tends to reuse this older language. So as we move from what I call the regional schools to the personal schools, in other words, the schools that are founded by a person, sometimes in the text it'll refer to the old names. So these are the four personal schools which, after being established, came to the juristic schools came to be narrowed to these four schools, which are still the major four schools in the Sunni world, although I would say they don't have the importance they once did, but nevertheless, Abu Hanifa and the Hanafi school, Malik ibn Anas and the Maliki school, Shafi and the Shafi school, and Ahmad ibn Hanbal and the Hanbali school. And different regions tend to, these different law schools tend to be associated with different regions, and the law schools have slightly different emphases, both in their rhetoric and in their practice. But again, these differences are pretty slight. So, for example, the Hanafi law school tends to allow more for intellect and reasoning in the process, and more for analogy, whereas the Hanbali school tends to reject this, and be the most focused on textual evidence, with the Shafis and Malikis being somewhere in between, but the Malikis, again, Malik ibn Anas being a hadith collector, the Malikis being focused more on hadith, and the Shafi'i being trying to strike a compromise. And Shafi'i was extremely influential, and really, Shafi'i was so influential that all four law schools came to use language that he developed, where there's a place for hadith, some place for analogy, even if the Hanbalis rejected in principle, they actually do it in practice. and so they all came to look more one like the other after in time. But it's important to know the names of these four schools. So here's where these schools tend to concentrate: the Hanafi in the Middle East, Indian subcontinent, the Maliki in North and West Africa, Shafi'i in East Africa, Southeast Asia, Hanbali in Saudi Arabia. Um, so interesting, it used to be that we thought of as, in the modern period anyway, the Hanbali is the most strict and the Hanafi is the least strict, but it doesn't always work out that way because of all kinds of factors. So, for example, the Taliban are Hanafi, and they're quite strict and quite inhumane in their interpretation of the law, and the Hanbalis are actually in principle, the most lenient when it comes to divorce, for example. At least Ibn Hanbal was. So, it's hard to stereotype in a very simple way how, like, where they are in terms of liberal versus conservative. It doesn't really work. They're scholastic visions, which almost like Supreme Court justices, have different guiding philosophies. So too, these different schools have fairly complicated guiding philosophies. So some more technical language, and I apologize for all this technical language, and I try to cut it down. This is actually the cut down version, if you can believe it, but it's just it's important in particular for Islamic law. You just can't get away from it. So here we are. We have a person who is qualified to analyze the primary sources, that is the Quran and the Sunnah, because of his expertise, his great learning. He's known as a mujtahid. Again, so from that root I talked about, the JHD, and what he's doing when he applies his intellect to the primary sources of Quran and Sunnah, what he's doing is called ijtihad. A mufti is someone who's qualified to answer questions, and those answers are called fatwas. So if you have a question about Islamic law, what you're looking for is an answer, and if someone who is qualified to give an answer is a mufti, and a qadi is someone who's appointed by the government. A qadi is somebody appointed by the government to give answers, and those answers, in other words, when it gets into the field of the government, there's actually a consequence in this world as opposed to the world to come. And again, just to remind you that that's the less significant, the this worldly punishment. The world to come one is more significant, for what it's worth. The other thing I'll say is that you may think that because the qadis are appointed by the government, that they have higher status, they're more important. In fact, at least in the mind of the medieval Muslims that we can read, they have lower status than the muftis. In other words, somebody who takes a government position, and remember, these governments were often not considered terribly legitimate. There usually was a sense, in most times and places in medieval Islam, that the caliph was corrupt. So someone who's on the dole from the government, their esteem goes down. So there's books about foolish qadis, and they tend to be has more reason to be suspicious of them because they've taken the position than a mufti who's thought of as more pure. In some ways, a tradition that goes on today, I think. So with that, let's turn to the classical theory of fiqh, as first formulated by Shafi'i, but that is, again, extremely influential for the history of Islamic jurisprudence until today. And it essentially has four elements: Quran, Sunnah, Ijma', and Qiyas. Quran being scripture, obviously, the Quran. Sunnah being the model of the Prophet, as reflected in Hadith. Ijma' meaning consensus, that is consensus of either the entire community or of all of the jurists. It's the latter that would become the classical meaning. In other words, if all jurists are in agreement, then that agreement itself constitutes a binding force and a source of authority. And the fourth is qiyas, again, analogy. You notice I put nas next to Quran and Sunnah. Nas means it's an unimpeachable source. In other words, it's binding and authoritative. And this is also significant because only a nas source can be used for an analogy. So you can only analogize off of a Quranic or Sunnaic source, not a consensus, or you can't, or something that comes out of a analogy. You can't use qiyas and do another qiyas and another qiyas. You can't keep building analogies. So they want to stick. The emphasis is to stick close to the Quran and Sunnah and not to get more than one step away from them. So in the Quran, you have these, let's call them statements that suggest to the jurist general principles. Statements that suggest to the jurists general principles, such as the punishing of an evil is an evil like it, and when you decide to punish them in proportion to the offense committed against you. And from these, the jurists formulated some broader principles. And then there are also verses which appear to be fairly clear, but also appear to be somewhat contradictory. So look at these. O believers, intoxicants, games of chance, and sacrificing the stones and arrows are the unclean words of Satan. So avoid them. Seems clear. Prohibiting intoxicants and gambling. Second one, on those who believe and do good deeds, there is no blame for what they consume while they keep their duty and believe and do good deeds. Well, the second one doesn't mention intoxicants, but it sounds like if you keep doing good, there's no blame no matter what you can consume. So you could, maybe that would seem like the second contradicts the first. So the jurists need to, found a way out of this to explain it. The way that they found out of this is this theory of abrogation, naskh. And what they decided was that God, at times, based on what he saw happening on the ground during the life of the prophet, would abrogate, that is, cancel out and update a previous revelation with a later one. And it's always the later revelation which holds. So if you think about this, you can see why the occasions for revelation of the exegetes, in other words, the occasions of when a Quranic revelation was sent down, is extremely important. It has legal bearing. And so with the later verses always canceling out the earlier ones. So you can see that to be a jurist also meant you have to be an authority on all these fields of Quranic sciences, like the reasons for revelation and the order in which the Quran was revealed. Now I said that ijtihad partly meant applying one's intellect to interpret the Quran. What the jurist said that there are three types of verses in the Quran. There are unequivocal or definitive statements by God. There are difficult and those speculative statements, and there are statements that are so difficult as to be utterly unclear. And it's really the second one that requires ijtihad. So in other words, just to give you, I'm going to give you some examples of each. Here's an unclear verse. Aleph Lam Mim, that just means basically it's the name of the letters ALM. That's a verse of several. That occurs several times in the Quran. It's, according to the jurist, it's utterly unclear what this ALM stands for, what it means. It has no bearing whatsoever and should not be the subject of ijtihad. It has no bearing on the law whatsoever, I should say, and should not be the subject of ijtihad. That is to say, it's uninterpretable, inscrutable. Here's a verse that the jurist found utterly clear. Those who accuse chaste women of adultery and fail to bring forth witnesses, flog them 80 stripes. So if you accused a woman of adultery and there are not 4 witnesses who have seen the act, a witness means someone who's actually seen the act of penetration in Islamic law, then that accuser gets flogged. So you can imagine the charge of adultery is extremely, extremely rare in classical Islamic society, because if you accuse someone and there are not 4 people who've seen the act in progress, you are guilty of a had penalty and will be flogged. Now, for these difficult verses, these verses that are the subject of ijtihad, the answer is, or the question one must ask to determine this is the apparent meaning subject to interpretation? Is what the verse seems to say that something that's interpretable. And if it is, then it's a mushkil, it's a difficult verse. That is one that the jurist can work on. So here, for example, here's an example: prohibited to you are your mothers and daughters. Now, God does not say explicitly how they are prohibited, but the jurists deem that it's reasonable to assume that what is meant is for sexual contact, and so that's what. So this is something that's, although not entirely clear, it's sufficiently clear that it can be interpreted. Here's another difficult verse. This is actually one of these hudud that I mentioned earlier. This is the highway robbery verse. The punishment of those who wage war against God and his messenger and strive to make mischief in the land is that he should be killed or crucified, or their hands and their feet should be cut off on opposite sides, or they should be banished from the earth. So this is difficult in the sense that it's unclear what the punishment is. It's also a little bit unclear as what waging war against God and his messenger is, I suppose, or making mischief in the land. So this making mischief in the land, the jurists came to interpret as highway robbery. That is, if you rob a caravan outside of one of the cities where the caliph's troops are not present, this is the punishment for this is to be killed. That's how they came to see it. But you can see even the punishment's a little bit clearer. Killed or crucified. That's a bit strange, because does that mean crucified? Or that their hands and feet cut off opposite sides? Is that separate from the crucifixion and being killed, or is that the way they are killed? All of this is a bit unclear. So it's a difficult verse. So all of the above was under the heading of Quran, right? So remember, just to go back, there are 4 roots of jurisprudence: Quran, Sunnah, consensus of the community, or ijma, and qiyas, or analogy. So now we're on B, the sunnah, the second of the categories. And so this essentially is the evaluation of hadith, and specifically the isnads. And I don't need you to know these terms that I put down, but just to let you know that there are these terms. A mutawatir hadith is a hadith that's been transmitted by so many isnads, so many chains of authority all over the Muslim world, that it's taken as unimpeachable, authoritative, clearly important, or binding, I should say. A mashhur is one that's not that well attested, but still plenty well attested. A had means that there's only a single or very few isnads, and these really one needs to scrutinize more carefully. And again, so it's the evaluation of the isnads of the hadith that is by means of which one establishes what the sunnah, that is the model of the Prophet, is. By ijma, we mean consensus of either all of the community members or jurists, the latter being the definition that's the most common. You may think, well, how is there possibly going to be consensus about, you think of all the jurists in the world, and there's Islamic world is big. And what they ended up meaning by this is that if everyone's been doing something the same way and no one's challenged it, that constitutes the consensus. So the best example is prayer. There actually isn't, it's not a Quranic, or there isn't a hadith which says how many times a day we pray, but Muslims have been praying 5 times a day for time immemorial, and the sense is that this must have been the earliest established practice by the Prophet, even without the hadith. So there's a consensus, since no one has broken that consensus, and that itself is a source of authority. So that's the way they conceive of consensus. So qiyas, or analogy, is really where all the action is. So this qiyas is, again, Al-Amidi defines this as what fiqh is really about. That is, how does one discover the intentions of the lawgiver? And so qiyas entails the interrogation and analysis of one of the Nas texts, that is the Quran and the Sunnah, to try to understand why God legislated the way he did in that Nas text. And so by doing so, to be able to discern if it applies to a new case, which one wants to know about. And that's what we mean by analogy. Analogizing why God ruled as he did in a one case that we know about and applying it to a new case that we want to know about. This is in other words, what did God intend with his statement? So here's kind of a neat and tidy definition from Ahmadi, the extending of Sharia value from an original case, which is called an asl, which literally means root, because the latter has the same effective cause, illa, as the former. So in other words, it's determining what the illa, the cause of the legislation was in the asl, the original case, to the new case, which is called the branch. It's good for Oregon. It's all this tree analogy. We have the root, the branch. Yeah. So yes, in qiyas you've got these four parts: the root or the asl case, that is the case you know about; the branch, the fara, what you want to know about; the illa, the effective cause between the two of them, and that's really the heart of the matter. Do they share the same illa? And finally, the judgment, the answer that one comes up with. So for the asl, the important things are that it must be Quran and Sunnah, and it cannot be based on previous qiyas. That is, one can't build up qiyas after qiyas. And if it's unclear, it's up to the mujtahid, the person doing all this, to clarify the objectives of the lawgiver. That is, what does God intend? So if the key to all this is ascertaining what the illa is, then how does one do it? Well, one does it by doing a linguistic analysis of the Quran or Sunnah, or in other words, the Hadith, and eliminating the alternatives. And then one sees in the source case and the new case, do they have the same, do these things concur? And if they concur, then they share the same illa, and the analogy applies to the new case. And it's easiest to explain this with an example. Well, I mean, actually, before we get to the example, here is what do we mean by linguistic analysis? Well, according to the jurists, God has clarified there are some particles of indication in the Arabic language. Again, this goes back to this is an Arabic Quran, and Arabic, being divine, is the medium through which God spoke. One has to investigate it very closely. So, for example, you have these words like le, which is a connector word that usually is translated as because of or on account of. So in Quran 1778, you have an expression like perform the salat prayers li, the setting of the sun. So here the effective cause of the evening prayer is the setting of the sun. And so this is a clear indicator of the effective cause, the illa, for the evening prayer that one can use to analogize in other cases if one needs to. So again, this is how one figures out what the illa is of the nas, that is the Quran or Sunnah text. Another connector is this connector fa, which just means usually it's like thus. So for example, the Prophet neglected something in the prayer, fa, he prostrated again, he prayed again. So in other words, fa being a clear linguistic indicator of what God intended. So let's take, now we go to our example. And this is the example I'm going to be giving you, or I gave you for your reading, a section of Ibn Rushd's. This is a famous 12th century jurist's Bidayat al-Mujtahid, the beginning of the Mujtahid. And it's really a primer, a very basic primer for jurists in training. So it's kind of like a 12th century textbook for jurists. And I've given you the section on intoxicating liquids to read for your primary source for next time. And the discussion section will be based on that partly. So just to go a little through this, what is it that makes khamar is the word in the Quran, meaning grape wine? What is it, or the exact meaning I guess we'll leave open. Let's just say it usually is come to mean grape wine. But what is it that makes khamar, let's just say, prohibited, excuse me. What makes it prohibited? Is it because it's liquid, because it's red, because it's acid, because it has a particular taste, because it's grapey, or because it can intoxicate? Now, here's the important thing. The fact that the mujtahid doesn't like intoxication is not sufficient for him to determine that it is the key factor. He must follow the rules of procedure for establishing that it is indeed the illah. In other words, he can't just decide we don't like intoxication, so that's the reason. He actually has to look at the language of the text to see why God prohibited khamar. To help them with this task, in addition to the linguistic analyses, the jurists have determined through their study of the Quran and Sunnah that God had in mind 5 human interests which he wanted to preserve that are sort of vital for the maintenance of human beings, and these are, and that is vital for their human beings in their attempt to get to the afterlife. And these are religion, life, offspring, property, and rationality. These are the 5 vital human interests. So, in other words, if there's something in the Quran or Sunnah which one can tie to maintaining these 5 vital human interests, then that is a key to saying what the illah, what the effective cause of the prohibition or prescription of God's intention was. So what you're going to see in Ibn Rushd is that he's going to go through and guide you through what the different rationales of these different figures was in determining whether, the nature in which khamar is prohibited or intoxicants are prohibited. And what I want you to do is try to see how they're using some of these concepts of analogy and tradition and these sort of nas texts and intellect and all these things to come out what's the solution. So I'm gonna leave this to your discussion section for now, but I want to give you, to sort of help a little bit with this language you're gonna be seeing, and just to remind you, when he talks about traditionists, Ibn Rushd talks about traditionists, he means the hadith collectors, the hadith transmitters. Khamar is the word for wine, grape wine, but they're going to be discussing what it means exactly and using different fields of knowledge such as lexicography, studying the origins of words to discuss what it means. By the jurists of Hijaz, he's referring again to the Maliki school of law. And just to give you, Ibn Rushd himself is a Maliki. So, when there's a debate, it's usually the Malikis win because Ibn Rushd is, after all, that's his school. By Iraqis or Kufans, they mean the Hanafi law school. And really a lot of these debates are between Malikis and Hanafis. And Bukhari, we talked about, I mentioned briefly, but to remind you, he's one of the key collectors of hadith. So remember, if there's a hadith that's in the collection of Bukhari, it's taken as unimpeachable. So this is going to be, I think this is enough to get you going with the analysis of the text.